Legal Talk on eRadio with Hahn and Hahn attorneys, and today joined by Wynand Pieterse. We'll be talking about the difference between latent and patent defects in construction. What's that all about? It sounds interesting. Wynand, a very big hello to you. How's it going?
Good, and you, Eon? How are you?
I'm good, thank you. Is everything fine there in Pretoria or Tshwane? Haven't switched off your electricity yet?
No, luckily not. Everything else is fine. The seasons are starting to change, so it's starting to get quite hot here.
Oh, that's nice, yeah. Except for the load shedding, of course, but I was actually referring to Eskom and their threat to disconnect the city of Tshwane.
Yes. Yes.
Yes, but they'll do it anyway with the load shedding. They'll disconnect you anyway. But anyway, but that's not what we're talking about today. We're talking about construction and the difference between a latent and a patent defect. Now, what on earth, Wynand, is the difference between these two things?
So firstly, when we talk about a latent defect, it stands in stark contrast to that of a patent defect. As the name indicates, a latent defect will not be visible or observable to an observable person or individual inspecting the property or the goods that may be sold. On the other hand, a patent defect will be clearly visible to an observable person. Therefore, the manner of the defect will determine whether the same is thus then latent or patent. The measure to determine whether a defect is indeed one of these two is that of a reasonable person which inspects the goods. The fact that a defect is visible to an expert or after an unusual inspection of the property or goods is not the measure to be used.
Okay, so Wynand, therefore, how is a latent defect defined?
So, Ian, when reference is made to a latent defect, it is firstly important to ascertain what has been established as being a latent defect and how same is defined in our law. So, a latent defect can be described as a defect in the property or thing being sold of a non-trivial nature that will influence the utility or use of the property and which was not disclosed by the seller or known to the buyer during the conclusion of the contract of sale, and which could further not come to the knowledge of the buyer by reasonable inspection of the property or construction works. In the famous case of Hollandine Brickworks versus Roberts Construction, the court stated the following pertaining to latent defects. It held that, broadly speaking, in this context, a defect may be described as an abnormal quality or attribute which destroys or substantially impairs the utility or effectiveness of the res vendita. When reference is made to res vendita by the court, it only means, in other words, the thing being sold for the purpose for which it has been sold or for which it is commonly used. Such a defect is latent when it is one which is not visible or discoverable upon an inspection of the goods. I refrain, however, from entering into the question as to whether to be latent, the defect must be not easily visible, nor is it necessary to consider what effect, if any, is produced by the fact that the purchaser is himself an expert in regard to the goods or employs an expert to examine the goods. So this is basically what I said just now before this explanation by the court that they just confirmed in this case.
Okay, and what are the characteristics of a latent defect?
So firstly, as stated earlier, a latent defect thus stands in contrast to that of a patent defect, which is easily observable. Secondly, the defect should further be of such a nature that it will influence the effectiveness and utility of the goods and or the property. As a result, defects that will qualify as latent defects will only be those that influence the use of the property. This will have to be established on an objective basis, determining whether a defect is latent or not. Lastly, the latent defect should have existed during the conclusion of the contract, and the buyer will be required to prove this fact when he wants to institute action against the seller. The buyer should further, during the conclusion of the contract, be unaware that the latent defect is present on the property or construction works that was built.
Okay, and can any warranties be given against these latent defects, Wynand?
Yes, definitely. So warranties against latent defects can exist through natural application of the law and that of contractual warranties. In any sales agreement, there is, through the application of the law, an automatic warranty against the presence of any latent defects, except to the extent that these warranties, through agreement, is excluded by a Pieterse clause. It is thus legally accepted that by entering into a sales agreement, by buying a property, that such property does not have any latent defects. If a buyer wants to avoid the consequences of a Pieterse clause, she will have to show that the seller knew of the latent defect and did not disclose it, as well as that the seller deliberately concealed it with the intention to defraud the buyer. The other warranties against latent defects is the well-known contractual warranties. The seller can contractually, either expressly or implied, warrant in favor of the buyer that there are no latent defects present in the property or that the property is suitable for the purpose for which it is bought. An implied contractual warranty is given if it is clear that the intentions and conduct of the contracting parties, being the buyer and the seller, on a balance of probabilities, shows that the contracting parties had the intent to tacitly agree that the property is fit for the purpose for which it is bought.
Wynand, what is a buyer's remedy for claiming damages for breaching any of the contractual warranties by the seller given against any defect?
The remedy for breaching of the contractual warranties is that of actio empty, what we call it, whereby damages with or without the cancellation of the contract can be claimed. Cancellation of the contract can only be claimed based on the actio empty if the latent defect is of such a severe nature that it cannot be expected of the buyer to keep the property or proceed or be satisfied with the construction works.
Okay, and what is meant when we talk about these damages?
So the nature of damages flowing from the breach of contract is different from delictual damages. Firstly, a party claiming damages for breach of contract does not have to allege and prove fault on the side of the defaulting party, whereas fault will have to be proved to be successful to claim delictual damages. Therefore, all that has to be proved is the breach of the contract itself, which may also in any event entail proof of fault to establish this breach. Damages for breach of contract, unlike damages for derelict, are normally not intended to compensate the innocent party for any loss, but instead to put that party in a position she would have been in had the contract been properly fulfilled or performed. The courts previously stated that the assessment of compensation for breach of contract is that the sufferer by such a breach should be placed in the position he would have occupied had the contract been performed, so far as that can be done by the payment of money and without undue hardship to the defaulting party.
Okay, and how are these damages then calculated?
So a buyer wishing to claim damages resulting from a breach of contract must allege and prove the following elements. Firstly, that there was indeed a contract being entered into between them. Secondly, that there was a breach of the contract, for example, that a specific obligation or term within the contract itself was not duly performed. That the buyer indeed suffered some form of damages, and there should exist a causal link between the contract breach and the damages. Then the damages suffered was not too remote by establishing that the wrongful conduct was probable the cause of the loss suffered. So the following rules also apply when calculating damages. Firstly, damages are usually but not always assessed as at the date of the breach of the contract. Secondly, the innocent party should be placed in the position it would have been had the contract been duly performed, insofar this can be done by the payment of money without undue hardship to the defaulting party. Thirdly, when there exist several ways by which the other party, being the defaulting party, might have performed the contractual obligations, the damages for the breach of contract are to be assessed on the assumption that the defaulting party would have performed in a way least profitable to the innocent party and most beneficial to such defaulting party. And lastly, should a party wish to use a special method of calculating the damages, the onus rests on such a party to satisfy the court that such a method is the appropriate one in the specific circumstances of the case.
And now our final question. What elements must a buyer allege and prove to be successful in claiming these damages for latent defects in a property?
So in addition to prove and calculate damages, the buyer will have to prove that the property had defects that was latent, as well as when the contract was concluded. The seller warranted as a term of the contract the absence of any defects or the presence of qualities lacking in the property or construction. The seller should have knowingly concealed the defects or knowingly represented their absence. The buyer can thus claim damages and or cancellation of the sales contract with the actio empty if the concealment of the latent defects resulted and had the intent of misleading the buyer and resulting in the buyer entering into the sales contract. It is therefore paramount that not only should the seller conceal the latent defects, but the seller should also have had the intention of defrauding the buyer. So, Ian, in conclusion, I would like to, for our discussion today, I will illustrate all that was said by a practical example. I think this will help the listeners in this regard.
Yes, let's hear it.
So, say for instance, someone buys a house or commences with some sort of construction. Then before the house is bought or the construction being approved, a due diligence assessment is, for example, done on the property. This assessment report will highlight all the defects that is present in the property and which will have to be rectified. These defects are thus patent and was observed and highlighted in the due diligence report. In addition, the sales contract entered into between the seller and buyer should have a warranty that the property is free of any defects and is fit for the proper use thereof. Should it come apparent at a later stage, say, that there is some other sort of defect that can be classified as a latent defect and was not easily observable on inspection, or when the due diligence report was compiled, the buyer can proceed to institute legal action against the seller for this latent defect being present in the property that is in breach of the contractual warranty and claim damages suffered for rectifying this defect by his or her expenses incurred. These defects should have been present and or existed at the time of concluding the sales contract. It will also have to be shown that these latent defects are of such a nature to severely influence the usability of the property for the intended purpose. Lastly, to be successful in claiming on latent defects, it should be highlighted that the buyer will have to prove that the seller deliberately and with intention tried to conceal this latent defect from the buyer at the time of inspection, as well as during the conclusion of the sales agreement. This conduct of the seller will thus be classified as fraud. It is therefore not always a straightforward exercise, as all the elements will need to be proved as mentioned earlier, especially the element of fraudulent conduct by the seller. Thanks, Ian.
Thank you, Wynand, Associate Attorney at Hahn & Hahn Attorneys in Pretoria, here in South Africa. If you want to get in touch with them, the number to call is 012-431-2480, or you can go to hahnlaw.co.za. That's HAHN law.co.za. Wynand, thanks for your time and your knowledge, and we'll speak to you again in the future.
Thanks so much, Ian. Speak to you again.
Are you or your business in trouble and struggling to find a solution? Call Hahn & Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn & Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn & Hahn Attorneys, Wednesday mornings at 10 on eRadio.